undergraduate program in Law, Faculty of Law, Universitas Islam Indonesia. Dear ladies and gentlemen, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Your Excellencies, the Professor at Ahmad Ibrahim Kuliah of Laws, International Islamic University, Malaysia, Professor Dr. Farid Sufyan bin Suaid, Honorable Associate Professor Dr. Suraidah Haji Ali and her husband Mr. Zulkifli Osman from International Islamic University, Malaysia, Honorable the Dean of Faculty of Law, Universitas Islam Indonesia, Professor Dr. Budi Agustuswandi, SHMU, Honorable the Head of Undergraduate Studi Program in Law, Faculty of Law, Universitas Islam Indonesia, Dodi Setiawan Nur Herianto, SHMH LLM, PhD, Honorable the Secretary of Undergraduate Program in Law, Faculty of Law, Universitas Islam Indonesia, Bagia Agung Prabowo, SHMU, PhD, Honorable the Secretary of International Undergraduate Program in Law, Faculty of Law, Universitas Islam Indonesia, Dr. Aroma Elmina Marta, SHMH, Honorable the Head of Cluster of Civil Law, Faculty of Law, Universitas Islam Indonesia, Abdurrahman Al-Faqih, SHMA LLM. Respectable all the lecturers on undergraduate program in law and unforgettable dear students, Faculty of Law, Universitas Islam Indonesia. Alhamdulillahirabbil alamin. First of all, let us pray, praise and thank to Allah Subhanahu wa Ta'ala, the Almighty, the most merciful, all over the universe, who has created the world belongs to all mankind. Only because of His blessings and mercies, we are all able to attend this agenda without any troubles and obstacles and with healthy condition. Secondly, may salawat and salam always be with our Prophet Muhammad sallallahu alaihi wasallam. Peace be upon him, the messenger of God, the most excellent worshipper, leader of God-fearing, supreme among prophets, the word inspiration and all human best example, who has guided us to the right path of life, namely Islam. Honorable speakers, dear brothers and sisters, welcome, ahlan wa sahlan, to guest lecturer from International Islamic University, Malaysia, Adat Law in Malaysian legal system. I am Muhammad Farhan Juliansyah as Master of Ceremony. On this great occasion, will deliver the structure of our agenda today. The first agenda is opening. The second agenda is the main session, guest lecture, Adat Law in Malaysian System by Professor Dr. Farid Sufyan bin Suhaib, guided by the moderator, Mr. Abdurrahman Al-Faqih, SHMA LLM. The next agenda, the Q&A question or discussion session, and the last is closing. Honorable speakers, dear brothers and sisters, the first agenda is opening. Let's open our agenda today by reciting Basmalah. Bismillahirrahmanirrahim. The next agenda is the main agenda. Guest lecture, Adat Law in Malaysian legal system, will be delivered by Professor Dr. Farid Sufyan bin Suhaib, the professor at Ahmad Ibrahim Kuliah of Laws, International Islamic University, Malaysia, will be guided by the moderator, Mr. Abdurrahman Al-Faqih, SHMH MA LLM, the head of Cluster of Civil Law, Faculty of Law. The floor is yours.
Assalamualaikum warahmatullahi wabarakatuh. Raditu billahi rabba wa bil islami dina wa bi Muhammadin nabiyya wa rasula. Rabbi zidni ilma wa rizqni fahma. Rabbi syrah li sadri wa yassir li amri wa hlul 'uqdatam min lisani yafqahu qawli. Allahumma anfa'na bima 'allamtana wa 'allimna ma yanfa'una وارزقنا علوما تنفعنا في الدين والدنيا والآخرة آمين رب العالمين. Thank you for the master ceremony for appointing me and allow me to have a seat here. My dear and my beloved, my honorable guests and participants, let me introduce myself first of all. My name is Abdurrahman Al-Faqi and I'm a teaching staff at this faculty, particularly in the private law department. So allow me to assist you, as a moderator for this forum. And we already have here our guest lecturer. But before going to inviting our guest lecturer, I would a little bit give a prologue or a context, bridging you into the main topic that we will discuss. As we all know that Adat law in Indonesia is a part of Indonesian legal system, and it is also acknowledgeable as unwritten characteristic law. To some extent, this Adat law embeds with religious values in Indonesia. So then, as a country with pluralist societies, Adat law plays an important role in Indonesia that increasingly adds the critical discourses of legal pluralism. Since it originates from the indigenous values based on habit to execute from the older generation. So if we take a look from back into one of our legal sources in Indonesia, particularly the Provisional People's Consultative Assembly, we call it MPR decree, in its decree number 2/1960 on the broad guideline of the first phase of Universal National Development Plan in 1961 until 1969, it stated that Adat law is no longer only part of national law, which is unwritten part, but it is the national law itself, both written and unwritten. And also Adat law is no longer understood as unwritten law originating from local custom. In addition, if we also refer to a doctrine or an expert opinion or view, we can refer to Supomo. Supomo is one of the Indonesian Adat scholar, notable Indonesian Adat scholar. He stated that the basic law of state is only a part of the constitution of state. The basic law is the written or codified constitution, while complementing the basic law is the unwritten or uncodified constitution. For example, basic rules that emerge and are preserved in the state management practices. Although unwritten, from this statement, Supomo would like to emphasize how important the Adat law is in this state, in Indonesia context. Moreover, Supomo is a founding father or the father of Adat law in Indonesia. He also argued that Adat laws are non-statutory laws, most of which are customary laws, and a small part of Islamic law. And also Adat law includes case laws based on judge decision that contain legal principle applicable in respective jurisdictions. He also stated that Adat law finds its root in traditional culture. And Adat law, therefore, is a living law because it is an actual manifestation of people's sense of justice. Accordingly, to its own inner quality, Adat law is continually in a state of growth and development, just like the life itself. So, from this context, Indonesian context, we can see that how important and how is the status of Adat law in Indonesia. Ladies and gentlemen, and also the honorable participant, I think it is important for us to know and also to compare Adat law in other countries, particularly in Malaysia, yeah, where, as we all know, yeah, Malaysia is our neighboring country that tends to have a similar culture clumps, a country that shares a common culture family. So accordingly, I think this is a golden opportunity for us to know and also learn what Adat law looks like in Malaysia legal system. Without further ado, I would invite our honorable guest speaker, an outstanding expert from IIUM, Professor Dr. Farid Sufyan bin Suhaib, to come to stage. Give applause to our speaker. All right, guys. I guess only both of us here, right? Although the seats, there are 3 seats here. Maybe Pak Agus would like to accompany us here. All right. So you will have a class. All right. So my dearest participant, my beloved students, before I deliver or I invite our professor to deliver his speech, I would read in a brief about his curriculum vitae. Yeah, Prof. Farid Sufyan Suhaib, Professor Dr. Farid Sufyan Suhaib. I'm sorry if I mistake in pronounce your name. Yeah, from Ahmad Ibrahim Kuliah of Laws, International Islamic University, Malaysia. He obtained his LLB honors from the International Islamic University, Malaysia, and was immediately offered a teaching post at the Kuliah of Law, IIUM, in 1993. And he also completed his LLM from Queen Mary University of London, QMUL, and obtained his PhD in law from IIUM. He received and completed research grant on administration of Islamic law, media law, and constitutional law, and also he published widely in Malaysian and international journals. Among his books are Administration of Islamic Law in Malaysia, Text and Material, Power and Jurisdiction of Sharia Courts in Malaysia, Constitutional Law of Malaysia, Text and Commentary and Media Law in Malaysia, published by LexisNexis, Pearson and Walter Kluwer, yeah, respectively. So he has been invited to visit and deliver a seminar in universities in England, Turkey, and also in Indonesia. His writings are referred to in the judgment of Superior Court in Malaysia. So that's about, in a brief, about our speaker. So before I deliver this mic to our speaker, I would also announce you a general rules and also the allocation of time that we have for our discussion. For the rules, I'm not really sure whether our speaker, Professor Farid, allow us to just jump in, interrupt if there is any question during your explanation. Okay, so then we will have about 1 hour, approximately 1 hour until 2:30. So then, if you guys have any question, just raise hand politely, and I will appoint you and then I will allow you to give your question. Or the second option, I may also collect the question after our professor finished his speech. Okay? All right, so the time is your professor to deliver Adat law in Malaysian legal system.
Should we hear or? Yeah. Okay.
It's okay. If you,
I have.
if you like to stand or...
Okay. Adat. Which one?
That's one? In front?
Oh yeah. Okay. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Thank you, Bapak Abdul Rahman, for as the moderator for today, and thank you also for the team from Universitas Islam Indonesia, Fakultas Hukum, Bapak Dodik, Pak Agus, Ibu Roma, and also Pak Dekan, Pak Badi, Pak Bagia. And of course, we have met also the Dean for Fakultas Hukum, Prof. Budi Agus. It's the first time that I arrived at the new campus of UII. The last time I came is at the old campus, slightly old building, I suppose. But this is a brand new, grand building, and as huge building, and I suppose it reflects also the scholarship, the grand scheme of things, of the things that the Faculty of Law would want to do, and hopefully we could collaborate in embarking upon our journey. So thank you for inviting me to speak on Adat law in the Malaysian legal system. Together with me, I have Dr. Zuraidah Haji Ali, the Director of Harun M. Hashim Law Center, who is also familiar on Adat law, since we have to teach matters regarding land law, including trust, which involve wakaf, harta pencarian, and so on, which involve the issue of Adat. So what I have shared, I can't say, there. Next, please. So, just to share for those who do not know where Malaysia is, I suppose. So, to show the Malay part of the Malay archipelago. Hopefully, you can see yourself where's Malaysia. We are in Java. In Java, then you have the Sumatra, the Borneo, and so on. And in the latest budget, some allocation is made to develop the town at the border between Sabah, Sarawak, and Kalimantan, in expecting the moving of the capital of Indonesia. So when Pak Abdul Rahman mentioned about the interconnected between Malaysia and Indonesia, that would be one part of it. Next, please. And this is the state, the provinces in Indonesia. I suppose we call it provinces, but in Malaysia we call it state, negeri. We have basically 13 states there, Perlis, Kedah, Penang, and so on, because this would explain the setup of Malaysia. We are a federalist country, quite central, but with certain autonomy given to the states. We have state executive and also state legislature. I suppose compared with Indonesia, Indonesia is more centralist. Next, please. This again, just to share some demographics so that you have an idea on the pluralist country that we have in Malaysia. So our total population will be around 32,000, and the ethnic and religious composition, we have Bumiputra. So Bumiputra is the indigenous groups which include Malay and the native in Sabah and Sarawak. That would fall under Bumiputra, which consists about the 70%. and Chinese 22 or 23%, Indians about 7%, and also we have the other ethnic groups. So Bumiputra there is 70% because that includes the Malays, the native, meaning the native Sabah Sarawak. Probably you are familiar with the ethnic of Bidayo, Murut, Iban. That would fall under the native of Sabah and Sarawak. And regarding religion, I suppose we are different from Indonesia. Muslims about 61%, so it's not like probably 95, 96%, 89% Indonesia. About 20% Buddhism, Christianity 9%, Hinduism 6%. So that's basically our composition. Next, please. Okay, talking about the legal system. Before this, I share some facts about the demography. If we trace, again, similarity with Indonesia, if we trace our history, the early history is also defined by Hinduism, Buddhism. I had visited Borobudur to show about the influence of Hinduism and Buddhism in Java, in Indonesia in general, and the same would be in Malaysia. And then you have the arrival of Islam, and with the gradual process of Islamization that you have. But the process was interrupted by the colonial intervention. Again, same history with Indonesia. So apart from the Dutch and Portuguese in Malaysia, we have the main colonial body would be the British for Malaysia. I suppose the Dutch would be for Indonesia. And if we look at this, we can see the convergence of influence. Before that, you have Hinduism and Buddhism, then come Islam. And with the arrival of colonial power, namely particularly the British, you have the influence of the common law or the English law in Malaysia. And what you can see from the influence of Islam, you have like the Hukum Kanun Melaka, the Pahang laws, the collection of laws or principles based on Islam as applied in the sultanates in the Malay states in particular, and also in Borneo, in Sabah and Sarawak. And if you look at the history of Malaysia, the Treaty of Pangkor will be one that you may come across. The Treaty of Pangkor 1874, it is sort of a template of treaties between the Malay sultanates and the British, where the British would continue to regard the Sultan as the head of state, but the head of state is advised by British resident or British advisor. So the de facto ruler would be the British, but the de jure or legally, the Malay Sultan is still the head of state until now. So we have the Yam Tuan Agong at the federal level, and you have the Sultan at the state level. For those states that have still have the sultans, except Penang, Melaka, Sabah and Sarawak do not have sultan. Oh yeah, just sultan and also the governor. Yeah, but we differentiate between the head of state and the head of government. So the sultan is still the head of state, but the head of government is the executive. So, with the arrival of the British, we have the imposition of the hybrid English law, meaning it's not really English law, but there's a mixing of Malay Adat, Islamic law, English law, and so on. So you have the mixing. And of course, that would produce, as mentioned by Pak Abdul Rahman, legal pluralism in Malaysia. So you have also legal pluralism in Malaysia. And of course, the effect of the arrival of the British is the marginalization of Islamic law, which most of the time happen in the colonial territories. Next, please. So this talk about the independence. So independence of Malaysia in 1957, and basically what we have before the independence, of course. To explain about the independence that we refer to World War I, World War II, and so on, which we will not go into. Um, what need to be noted is that you have insurgencies against the British. At the same time, also you have the parallel road towards independence through the negotiation between either the elites in Malaysia or in the Malay states at that time, the royalties and so on, and also the community leaders in Malaysia. And in 1957, before that, what we have mainly is Malays, with some probably Chinese, Indian, and so on. But with the arrival of the British to exploit the resources, communities from China, communities from India, to exploit the natural resources, to work on the plantation, to work on the tin mines, and so on. So there is changed landscape of the Federation of Malaya Sultanates, where there's mainly Malays as inhabitants, as the population, with now Malays at one time in some territories become the minority and so on. So the constitution, the independence requires a written constitution, because there is a drastic change of governance from the Malay states to the British, and then you want to have independence. So that explains why we need to have written constitution. In contrast, for instance, the British who do not have quote-unquote written constitution. So the setup that we agree is to have federalism, where basically there is different units coming together. Different units here refers to the sultanates or the states coming together to agree to form a new unit, a new overarching unit of federal unit, namely Federation of Malaya at that time. So that's the concept of federalism. And in the negotiation, it is agreed that most of the powers is given to the federal government, with some powers maintained at the state level, particularly on the question of Islams and Malay Adat. That would still remain under states, but question of education, defense, finance, and so on would be under federal government. And that's in 1957. 1963, we have the formation of Malaysia, which includes Sabah, Sarawak, and Singapore. In 1965, Singapore left Malaysia. So that's the history a bit. Next, please. Okay, so this more in line to our main discussion today on Adat, but I suppose to give a general overview on that, we look at the sources of law in general in Malaysia. So we have first reference will be the federal constitution and the state constitution. Because under federal constitution, there's the idea of supremacy of constitution, meaning the constitution is supreme. Any law which is in constitution shall be void. That's the provision of the constitution. And second source will be the Islamic law. It is described by case law, by decision of the courts, that Islamic law, the territorial law of the Malay states. And Islamic law here is understood under, because Bapak Abdul Rahman mentioned about the unwritten law. So this would be the understanding of Islamic law here as an unwritten law. Unwritten law in the sense that it is not passed by a legislature. Because Islamic law, of course, you may find Islamic law in written form, isn't it? In Quran, in Hadith, in the writings of juries and so on. But here, unwritten means not passed by legislature, temporal legislatures. Formal procedure. The third would be the legislation. Apart from federal law, state, you have the federal law, meaning law passed by the federal legislature. State laws passed by states, known as state law. And there is the idea of primacy of legislation. I think we are influenced by the idea of positivism, where we put primary consideration on what is legislated, what is passed. That's, I suppose if you look at the cases, that's one thing that we probably notice. Because we are under, we have the influence of English law, judicial precedence is also our source of law. I suppose in contrast to Indonesia, under civil law, the judicial precedent is not really a source of law that, but of course may influence, may guide the subsequent decision. The fifth is English law. Although English law is a foreign law, one of the laws here refers to Civil Law Act 1956, allows for the application of English law in certain circumstances. And next is customs. So custom is also a source of law in Malaysia. And because of the different, the demographic that I have explained to you, so we have the Malay customs, you have the native customs, you have the Aboriginal custom, and also the Chinese custom, Hindu custom, and so on. So you have different custom which is recognized as a source of law. Next, please. And what we can see here from the sources, from demography and so on, and also from the history of Malaysia, we have legal pluralism. So what is legal pluralism? Here it may refers to a situation where laws are not administered only by official institution. So this one approach to legal pluralism where you have official law and unofficial law. Second perspective of legal pluralism is where the state recognized and provide different laws for different groups in society, either based on ethnicity, based on religion, or even based on profession, age, and so on. So that's the two perspectives on legal pluralism. Next, please. And because not only we have different sources of law, we have also different courts in Malaysia. In Indonesia, you have the Peradilan Negara, Peradilan Negeri or Peradilan Negara? Peradilan Negara, Peradilan Negeri, Peradilan Agama, Peradilan Tata Negara, military, and so on. So in Malaysia, we have the civil court system, the Sharia court system, the native court system. So in the civil court system, we have the federal courts, court of appeal, high courts, magistrate court. This is under federal government, basically under the purview of the federal government. Then you have the Sharia court system, which applies for the civil courts is applicable to all, administering all laws for all parties. The Sharia court system applies Islamic law mainly for Muslims, where Islamic law is applicable. And it has its own system, the Sharia appeal court, Sharia high court, Sharia subordinate court. And the third court system we have, the native court system, which is different in Sabah and in Sarawak. We have the two states in Borneo, Sabah and Sarawak. They have their own native courts. So the native courts applies applicable to the native as defined. Later on, I'll make reference to the definition of native. Applicable to native and applies native customs only in Sabah and Sarawak. It is not applicable in the peninsula, only in Sabah and Sarawak. Next, please. So talking about Adat. So which Adat? So we have in the Federal Constitution Article 160 where it provides definition, and one of the definition is law. And here it defines law as includes customs having the force of law. So this would be the starting point in most of the discussion of what is the status of custom in Malaysia. Reference will be to the Federal Constitution that says law includes custom having the force of law. In other words, customs is one of the sources of law. And there is the recognition under the Federal Constitution for that. And to define in more detail what is native customs, you have to refer to different laws. For what is custom itself, you may refer to other laws. But an example would be the Sarawak Native Court Ordinance 1992. The law of Sarawak, which says a custom which the law give effect. Not much definition there. So quite a secular definition. Law includes custom. Custom is what law give effect to. So does not really explain anything. And in the decision of the court, how you determine a practice, as mentioned previously that custom is the practices and so on. So which practice that can be recognized as adat law or customary law? So if you look at the cases, among things referred to the court is the long usage. You have to show there is long usage of that practice in a particular community. So it is a question of fact. If you want to say in the dispute, you want to say this is a custom, you have to prove that it is a custom. By oral histories, for instance, you invite elders, a prominent person in that community, or a scholar, a professor, to give evidence in the court that this particular practice constitutes custom. There's a long usage, that community rely on that practice and so on. Right. So when that happens, then the court may accept it as a custom that can be given force by the court. The other elements of the custom, that the custom or the practice should be reasonable and not contrary to public policy. So if you have established it is a long usage, long-standing practice, but the court says it's not reasonable, it's contrary to the public policy. For instance, there is probably customs somewhere in the world. There's a practice of that a widow have to kill herself. Then the court probably would say that it's not reasonable and contrary to public policy, could not be accepted as a customary law. Next, please. So that's the definition in general. What is adat or custom? And what are the customs that you can find in Malaysia? First, you have the Malay adat. In the textbook, usually there is a distinction between the adat Temenggung and adat Pepatih. I suppose the emphasis here is on adat Pepatih. And again, this shows the connectivity between Malaysia and Indonesia, because adat Pepatih is basically from Minang, from Sumatra, West Sumatra. So the community from West Sumatra that came to mostly in Negeri Sembilan in the peninsula, they established there and so on, and they have their own customs. Emphasis is made on the matrilineal succession of the property or of the estates. So that is recognized in Malaysia. We have statutes giving recognition of adat Pepatih, particularly on the succession or distribution of estates, on land tenure and inheritance. So you have different laws applicable in Negeri Sembilan that give recognition to adat Pepatih on the question of land tenure, harta ibu dan sebagainya, and others on inheritance. And so apart from that, adat Temenggung, I suppose is the other type of adat referring to the election. Some probably would not be regarded as customary law regarding marriage, not divorce, I suppose, the preliminaries of the marriage and divorce and so on. And we have also harta pencarian or harta bersama. Probably in Indonesia you have also gonogini. Yeah. So we have this is quite interesting because in the early recognition of harta pencarian, the court refers to as adat, Malay adat, but later on it is put under Islamic law. Of course, Islamic law also recognize adat, so that's another separate discussion, I suppose. And then, apart from the Malay adat, which is in the peninsula, you have also the Malay adat in Sabah and Sarawak, because you have also the community of Malays in Sabah and Sarawak. And then you have the native customs in Sabah and Sarawak. And who is the native? You have to refer to the Federal Constitution, define, basically listed out the different ethnic groups in Sabah and Sarawak. And you have also the state law of Sabah and Sarawak that define who are the native. So that's, and this marriage, adoption and so on, that would be under native. And also some criminal law also, you have also under native custom in Sabah and Sarawak. Apart from that, you have the customs of aborigines, or we call it orang asli, or now they refer to as orang asal. The aborigines in peninsula. No, yes, different. Orang asli is different from Bumiputra and different from native of Sabah and Sarawak. And they may the emphasis of course they have custom of marriage, divorce, and so on. But in the case law, dispute that come to the court mainly on rights over land, because usually when we want to build highways, new toll road, new highways, new airport, will take over the land that has been used by the Aborigines, and there's question of compensation. If they are not the lawful owner of the land, probably the compensation will be very low, or there's no compensation. But if they have rights over the land, then the government has to give more compensation to them. So usually the dispute in the courts is whether or not that group of orang asli or orang asal have rights over the land, and they will refer to customs. Whether that is their customary land, if those land that has been taken over is their customary land, and the court will recognize they have rights over the land, and if that is so, then more compensation should be given to them. Next, please. Apart from that, you have also Chinese customs on marriage, divorce, and inheritance. The fact that the famous case law that is established that you have polygamous marriage for the Chinese under their customary law. You have also Hindu customary law. But for the Chinese and Hindus in particular, you have to consider the Law Reform Marriage and Divorce Act 1976. Basically, before this law, every time you have dispute, most of the time because of estate, distribution of estate, to distribute the estate, you have to establish who are the lawful beneficiaries, which include children. In order to recognize them as children, you have to find out whether there is marriage. So, whether or not there is marriage, you refer to customs. And you have to show proof. You have to bring proof that there is ceremony of marriage and so on. Right. As defined by customs. What is the requirement? There's tea ceremony, for instance, for the Chinese. So it creates problems also to establish valid marriage, to establish legitimate children, and so on. So that's among the thing done under Law Reform Marriage and Divorce Act to require the registration of marriage. So before this, under customary law, there's no requirement of marriage. But if there is a dispute, it creates difficulty. You have to prove the marriage. But if you have registration, of course, you just refer to the registrar, whether or not there is valid marriage or not. So Law Reform Marriage and Divorce Act is not applicable to Muslims. For the native and orang asli, there's an option for them to use the act or to register under the act. And the law reform also say that it is an offense for bigamy or marry more than one wife. And of course that's because before this, for the Chinese, they also can have more than one wife under their customary law. So this law reform then stopped the practice of polygamous for the non-Muslims, Not only Chinese. Because for the Hindu customary laws, it depends on the ethnic group. Some of the ethnic group also recognize polygamous marriage. Next, please. Okay, so those are some of the application of Adat. So the question now is custom still relevant in Malaysia? So based on our discussion, if you refer to the Malay Adat, of course, you have Adat Pepatih, which is still recognized in Negeri Sembilan, even in land tenure and also inheritance. For dispute regarding the sultanates on question of succession of the sultan and so on, you still refer to Adat, to the custom, so it's still relevant in that regard. Chinese and Hindu custom, not much, because you have the Law Reform Marriage and Divorce Act, which basically only recognize registered marriages. There's also law on inheritance, specific law on inheritance for the non-Muslim and so on. the Law Reform and Divorce Act does not prohibit the conduct of customs, but it does not recognize if it's only merely based on custom. Meaning, for now, what happens is that you need to register, but at the same time you can have the ceremony. So you do both, then you get the recognition under the Law Reform Marriage and Divorce Act. So for the native of Sabah and Sarawak, it's still much relevant because you have the native courts, so you have the application of native customary law in Sabah and Sarawak. For orang asli or orang asal, still relevant for them, and also still relevant for the courts. And particularly from what we can see is the dispute regarding lands and so on. So I suppose similar to Indonesia, customary law is also still much relevant in Malaysia, although you have to take into account with the legislation, the constitution, the common law and so on. Next. Okay, I think this is some of the book referred to that there is a question of custom that has been discussed. If you are interested, then you can read up for more detailed discussions. Thank you.
Okay, give applause to our. Thank you so much, Professor Farid. A lot of things that we insightful explanation that we get from Professor Farid. I guess we still have 40 minutes for discussion. Okay, I cannot conclude, but I believe that you take a note, right? Also, I put my notes also here that our professor state Malaysia is a federal country, have a legal pluralism and also plural court system. Yeah. They have two constitution, federal constitution and state constitution, and he also explained more about Adat Pepatih, right? Instead of many Adat for Malay, yeah, in Malay particularly, and also he explained many kind of Adat or custom, right? Chinese, orang asli, native, and Malay Adat. All right, guys, without further ado, any questions or comment from you? This is not a question, but I invite you. Maybe I have my class here. Maybe I recognize my class participant and I will ask to ask a question, to comment, to give a comment. But before that, maybe I will stimulate a question or comment from your explanation. So, if I'm not mistaken, that there are many Adat, right? Particularly in Malay also. So, what about Muslim? So, they still rely or apply Adat law, or they use Islamic law? Because if I'm not mistaken, Malaysia also recognize Islamic law, right? In their constitution, if I'm not mistaken. Yeah. Or actually Malaysia is not recognize Islamic law in their constitution. Therefore, Muslim in Malaysia will use Malay Adat law for their marriage, maybe for inheritance issues and so on. Yeah, before jumping to your question and comment, would you please just give a comment? Thank you.
Okay. As early on, before the proper administration of Islamic law, and I have referred to the issue of harta pencarian, for instance, when the cases went to the court, I suppose the judges would be more familiar with the customs rather than, because under custom you can call evidence, and the expert can explain to the court what is the customs in point. So in Sabah also it happened that there is the Malay customs on adoption, which may be contrary to the Islamic principle. So in earlier parts of the administration, there's a certain uncertainty and also disputes when you have a question on the application of Malay Adat and question of the application of Islamic law, particularly if the Malay Adat is contrary to Islamic law. Question of adoption, for instance, question of succession. But for now, on the question of personal law of a Muslim, like marriage, divorce, succession, and so on, the applicable law is Islamic law, and the courts that you have to go to is Sharia courts. So if you go to Sharia courts, then of course there's no question that you have to apply Islamic law. But of course with the caveat that Islamic law also may recognize customs. But the application would be through the principle of recognition of custom, not that the custom itself is applicable. So for now, there's not much an issue, because the applicable law will be Islamic law, and the court that have jurisdiction is Sharia court.
Thank you, Prof, for your explanation. To be honest, I'm not Adat law lecturer because I haven't delivered this subject. But yeah, this is something new also for me. I learned something about Adat. Actually, Pak Eko, maybe Pak Eko, is he still here? Pak Eko? Pak Eko is Adat law lecturer in our faculty. Yeah, it's okay. I will jump to participant. Any question or any comment? Or I appoint my member class, yeah? You have a question? All right. Please tell your name and introduce your name before you give your question. Thank you.
Oke, saya duduk atau berdiri? Stand up. Okay. Okay. Thank you for Mr. Farid for your explanations. So my name is Siti Aulia. You can call me Aulia, and I have one questions. Are there in Malaysia itself there is penghayat kepercayaan? And because in Indonesia itself, like Sunda Wiwitan, where the existence is of their belief has not officially recognized in civil records, such as in KTP. And how about in the Malaysia itself? Thank you. Penghayat kepercayaan.
Okay, so I suppose the question is on recognition of religion by the state, specific belief. In Malaysia, we do not have an issue of that, legal issue of that. So in a way, it has not been tested yet. If there is any claim that we now have a new religion, we want to get recognition under, because we have under the federal constitution, we have the freedom of religion. But usually when we discuss about religion in Malaysia, we refer to the established religion, Islam, Buddhism, Christians, and so on. It is still not an issue that there is a group of people going to the court saying that we want, because there is some, there's also, apart from freedom of religion, to profess and also to practice, and also rights also to govern their own education under religion. So it has not come arise in Malaysia where there is a new religion that claim those rights. So we do not know yet what will be the situation, because there is no specific law that says this is the recognized religion 1, 2, 3, 4. There is no such law. Now it's just the implicit recognition of the established religion. So we have to see quite an interesting issue also, if there is a dispute in Malaysia about a new religion. So probably Indonesia, it is an issue.
Yeah, maybe because, for example,
Mhm.
the older people in Java, they believe something that has a whole like a God.
Mhm.
They believe it and they have a kind of specific ritual.
Okay.
Then they establish that terminology. As you say,
Kepercayaan.
so that's specific. It happens in the community, but it doesn't recognize by the government doesn't recognize it.
Yeah, we have, for instance, animism in Sabah and Sarawak, animism, but as far as I know, there's no dispute about their rights to practice. So,
But in terms of the fact in the community, it is existing, right?
yeah, it's existing. Yeah, there's no issue because they're the native there, and they are indigenous community with their indigenous belief, similar to orang asli or orang asal also.
Okay, thank you for interesting question. Any question? Any other? Maybe Bubu. I recognize Bubu. He's my. Oh, sorry. Before to Bubu, guys in the middle. Yeah, just introduce your name and
Okay.
jump to the point of your question.
My name is Ridho. I want to ask two questions. The first one is there any dispute in recognizing Adat law in the society? And then the second one, what is the consequences of the recognizing toward Adat law society? Is there need any government decision or government rules or something else? Okay, thank you.
Okay, so let me take the first one.
The first one.
If there is there any disputes regarding recognition of Adat law? I suppose the disputes, recognition of Adat itself, there's not a dispute. Dispute arise if there is a conflict between Adat law and other laws. For instance, the example given by Pak Abdul Rahman on the issue of Adat in Islam. So previously there is a question of recognition of Adat, for instance, because it's contrary to adoption in Islam, for instance, but in Adat, in native custom, Malay Adat in Sabah, or in Sarawak, if I'm not mistaken, that they are treated as their own children. I mean, in terms of succession and so on. So if there is a conflict, then there is a dispute. And also if there is some implication to the society. At one time, about probably 5 years ago, as I mentioned, the native courts also have some criminal jurisdiction because there is offences under native custom, offences of sexual relationship before marriage, for instance. It is also an offence under the native customs. So some were prosecuted under native courts, but if involve statutory rape, meaning sexual relationship with girl underage girl, and it's considered as statutory rape under the penal code, and if you go to the ordinary courts, but you may have lesser which probably involve imprisonment. But if you go to the native court and the native customary offences, it may not involve imprisonment. You have just to pay compensation and so on. So there is also an issue arise there, whether that should be allowed, because this involves statutory rape, whether there's an option to go either to prosecute it under the ordinary court or peradilan negeri, or should it also be dealt under Adat. So those kind of dispute we have in Malaysia.
So sorry, I just jump into that question. If there, we assume that if there is a conflict between Adat and also the other law, So how to settle this? Which court that should deal with this or solve this dispute? Is it bring to Federation Court or a specific court or Adat Court? Yeah.
With Adat and Islam, as I explained earlier, there's not much difficulty in practice because the constitution says that Sharia court they have the jurisdiction. So if you go to Sharia court will apply Islamic law. After the amendment in 1988 in the federal constitution, before that you have dispute, but after that you don't have any dispute with regard to Adat. On, for instance, on the sexual rape, the issue that was raised is on an administration basically, or the prosecutorial discretion, whether the public prosecutor should prosecute in the ordinary court or whether to allow the prosecution in. So it was not brought further than that. It's a question of administration. So it has not been tested, but there is no law that provides the formula for the conflict for Adat and ordinary laws. Meaning you have to go to the court and for the court to explain it, because there is no specific provision either in constitution or in any law that explain if you have conflict where you have to go.
Yeah, yeah. Okay, I think the second question I forgot. Sorry.
What is the consequences of the recognizing toward Adat Law Society? Is there need any government decision or government rules like? Yeah.
Adat Law Society, what do you mean by?
The consequences of Adat law.
I mean, in Indonesia we have like government rules,
Yeah.
like Perda about a special region,
Yeah.
like Aceh.
Yeah.
Yeah, so yeah, like that.
Okay.
Is there any?
Or whether there's any recognition. I think certainly there is a recognition for, as I mentioned, under the federal constitution, custom is one of the sources of law, and in practice, in Sabah and Sarawak, certainly it's recognized, because not only you have the in a way codification of the native customs, you also have the native courts to implement or to apply the native customs. So certainly in Sabah and Sarawak, it's clear there is the recognition and the application of customs. In the peninsula, you have a bit more limited, but you have the application, for example, on the Adat Pepatih. You have the recognition, the law that recognize those Adats, and also some issue with regard to succession, royalty or sultanate succession and so on.
Okay, thank you, Prof. So yeah, waiting others want to ask another question. I also maybe would like to, get a more explanation perhaps regarding the criminal code or criminal law, criminal aspect. If I follow your explanation, kind of custom, many types of custom law, yeah, Adat law like China's and also native. There are the scopes of that law only about marriage, successor, inheritance, and polygamous, yeah, which is about marriage. But what about the criminal aspect? Is there also any specific rules in perspective of Adat regarding this aspect? Penal or criminal, yeah.
For the Chinese and Hindu's custom, the cases that come to the court is on the family matrimonial matters, marriage, divorce, inheritance. There's no issue of the personal law aspect, because basically at that time what you have is the judges train, British train or British judges at the time. So the application most of the time would be the application of English common law. The exception given by English common law is on personal law, to apply the personal law of the parties. So not on the criminal law. But you have the offences under the native customs for Sabah and Sarawak.
All right, we still have 15 minutes. I will invite another participant, maybe from the right side or the middle. Okay, in the front. Bubu, are you ready for a question? No.
Okay, Assalamualaikum warahmatullahi wabarakatuh. My name is Andi Erik Batara, and I want to ask about the implication of Adat law for the recognition of land ownership right by indigenous people in Malaysia. Because in Indonesia we have tanah ulayat, the ulayat land, are land controlled by indigenous people as part of their traditional right. Thank you.
So we have, this would be, I suppose applicable to two groups of people. One is the Orang Asli or Aborigines, and then the native in Sabah and Sarawak. Because the court have give recognition for their customary land rights. For the Aborigines in Peninsula, we have several cases that give those recognition, involving with, as I mentioned, development of new airport, development of new highways where they take away the lands of the Aborigines. So the dispute went to the court, and the court recognized the customary land rights of the Aborigines. The same also for the native in Sabah and Sarawak. There's also disputes when their lands is taken over for plantation and so on. So what are their rights? Reference is also made to the customary land rights of the native in Sabah and Sarawak. Tanah Wilayat. Yeah. For in Malaysia, different ethnic group may have different terminology. You have Tanah Temuda and so on. So you have different terminology, but basically they are on customary land rights. Right.
Okay. I think it was very interesting. Any other? We still have 10 minutes. So yeah, this is because a guest lecturer, it assumed we are in a class. Yeah, this is not like a general lecture or like a general seminar, like a forum, seminar forum. So then, yeah, please feel free to ask a question or to, a comment, give a comment. They are all, I think, in the second year, or in the third year, semester. What semester are you guys? Semester 2 and all of you? 2, 4, and 6, I think. Yeah. And for semester 2, you are taking Adat law, right now, subject, right? Yeah. What about semester 4? Have you? I think you already took Adat law, right? Last year or last semester, and also semester 6. Yeah. So yeah, this is quite interesting because we can compare what is Adat law in Malaysian legal system. I conclude that there is no other questions. Then thank you very much for Prof. Farid for your insightful speech and also knowledge. Yeah. Hopefully it would be beneficial for us. And thank you again for your kindness. Thank you guys for your cooperation and also attention. And I apologize if any inconvenience and also mistakes from me. Let we give applause to our professor. Thank you so much, and also for us. Thank you so much, and see you next time. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you to Professor Dr. Farid Sufyan bin Suhaib and our moderator, Mr. Abdurrahman Al-Faqih, SHMA LLM, that have guided us to the guest lecture this afternoon. Okay, so the next agenda is closing, but before we close, we have one last session. It is the handover of souvenir and certificate by the head of undergraduate study program in law, Faculty of Law, Universitas Islam Indonesia, Mr. Dodi Setiawan Nur Herianto, SH, MH, LLM, PhD. The floor is yours. The last agenda is closing. Let's close our agenda by reciting Hamdalah together. Alhamdulillahi Rabbil Alameen. In kafaratul majlis, subhanakallahumma bihamdika. Ashhadu an la ilaha illa anta, astaghfiruka wa atubu ilaik. I am Farhan Juliansyah as the master of ceremony. We thank you for your great effort and also attentions. إن وجدتم مني الأخطاء فمني ومن الشيطان وإن وجدتم مني الصواب فمن الرحمن أطلب منكم المعذرة فمن الله مغفرة والسلام عليكم ورحمة الله وبركاته.